So when is a school issue a legal matter? Sometimes you just need to know, and that might be something you know about the person you're dealing with or the profession of the person you're dealing with. I have been called probably 150 times in my career and told that there's a difficult conversation with a parent, and the parent happens to be a lawyer. But I'm going to provide, I think, a subset of the broad array of examples of what might be a legal issue, so you sort of know, at least the easy ones. So anytime the other party gets a lawyer involved, you should be in touch with school counsel. That doesn't necessarily mean that school counsel needs to take over. Lots of circumstances are, I think, a cooperation between school counsel and the head, but you should get them involved. Some of that, sometimes that occurs in an official capacity. Sometimes someone will say that they've spoken to a lawyer and the lawyer has told them X, Y, and Z. You can imagine this, maybe you've experienced this with, for example, a parent. I think that is somewhat of a gray area, but it's an easy place to pivot away from a conversation that is potentially problematic. That someone says they've spoken with a lawyer and a lawyer has told them the following. That's an opportunity, I think, for a head to say, well, this is apparently a legal issue and I need to be in touch with counsel, and it may be necessary for you to follow up, or your lawyer to follow up with the school's lawyer. So a few more examples. When reference is made to a law or legal ruling, we live in a society full of laws, and I'm sure all of you can understand many of those. But you do lack two things, and one, well, maybe one thing. One is probably experience with the issue. That probably depends. But the other is liability insurance. Your school lawyer should have substantial liability insurance, and that's a nice thing when they tell you how to act. Joe, do you want to just jump in here and explain indemnification in this context?
Correct. The practical impact of this is stated here that very often insurance will only apply, or you can only be insured for something if there was a reasonable belief that the action or omission was lawful. What that means in terms of practice is if you emailed your school counsel about an issue or before you took an action and the attorney said, yes, that is lawful, that is now something that you can show that you made a good faith effort to confirm that it was lawful. That will get you insurance coverage if that is the applicable standard. And then that also, it shifts the blame, so that if there's a dispute about whether something was lawful and you relied on the attorney's advice, you can now say, well, I was relying on my attorney.
So the last thing on this slide is when contemplating an employment termination. Employment law represents a huge percentage of the litigation that schools deal with. And terminations obviously breed lawsuits. So I would encourage everybody to, prior to an employment termination, reach out to counsel, get their advice, explain the situation, and make sure that they have legal support in the event that the termination leads to litigation. So a few more examples: when contemplating a student dismissal, when it's not clean, or you don't have a recent good reason that explains the dismissal. I'm sure there's always a good reason, but sometimes that reason is not apparent to everybody. When negotiating a legal contract on behalf of the school other than your standard employment and enrollment contracts, particularly the letters of appointment, but sometimes the enrollment agreements as well, depending on whether you're using enrollment agreements and what the nature of those are, should be reviewed regularly. And then in matters involving real estate and tax. Lots of times the firm that is school counsel can also give you advice on real estate and tax issues.